Thank you. Please be seated. Yeah. We have 3 cases set on our docket this morning, the first of which is styled Melton v. People. We've set that for an hour argument. Looks like both counsel are situated. Counsel for petitioner, why don't you begin when you're ready?
May it please the court, my name is Liz Porter-Merrill. My attorney registration number is 38447, and I'm here today on behalf of the defendant petitioner, Mr. Johnny Melton. To address the issues upon which certiorari was granted and the rules this court should adopt, first, during an abbreviated proportionality review under the 8th Amendment, courts should consider the evolving societal views on crime and punishment as reflected in legislative changes. Second and third, neither drug possession nor theft are grave and serious as a matter of law, and neither offense is grave and serious in this case. And finally, Mr. Melton's 24-year prison sentence for simple drug possession of trace amounts of drugs, constitutes cruel and unusual punishment because today, based upon multiple legislative changes to 3 different statutes, he would not be eligible for habitual offender sentencing. More importantly, today, Mr. Melton would receive at most a 2-year sentence. His 24-year sentence is 12 times the sentence he would receive today. The 8th Amendment's protection of human dignity reflects the nation we have been, the nation we are, and the nation we aspire to be. That's the United States Supreme Court in Hall versus Florida in 2014. To effectuate that constitutional protection of human dignity, courts must look beyond historical conceptions to quote the evolving standards of decency that mark the progress of a maturing society. That's Trope versus Doles in 1958, as well as Graham versus Florida in 2010. The 8th Amendment is, quote, not fastened to the obsolete, but may acquire meaning as public opinion becomes enlightened by humane justice. That was the U.S. Supreme Court in Weems in 1910. And as Brian Stevenson recently argued before the United States Supreme Court in our argument in Madison versus Alabama in May of last year, the 8th Amendment is not like other constitutional amendments. It's not just a window through which we evaluate government behavior. It's a mirror, because how we punish someone says something not just about the person who's been accused, but it says something about us as a society.
Ms. Porter-Merrill, good morning.
Good morning.
Can I jump ahead a little bit to if we were to agree with you on the theft and the possession, there's also the question of whether this is disproportionate. Do you think that's something that would be appropriate for remand rather than us deciding?
Yes, I think that I asked as my remedy that this court find that the sentence was so grossly disproportionate that it's unconstitutional. But alternatively, an appropriate remedy would be to remand to the trial court for an extended proportionality review.
Right, thank you.
So changing views on crime and punishment must be a part of abbreviated proportionality review because, as the U.S. Supreme Court said, the standard for extreme cruelty is not merely descriptive, but necessarily embodies a moral judgment. The standard itself remains the same, but its applicability must change as the basic mores of society change. That was in Graham, as well as Kennedy versus Louisiana in 2008. This rule that you consider evolving standards is consistent with every Court of Appeals decision on this issue over the last 20 years as of the point of the briefing. So applying the AG's view, as well as the rule of Harmland that's been adopted by Colorado, as well as Colorado's adoption of certain offenses being judicially designated as per se grave and serious, or as a matter of law, the 8th Amendment is essentially rendered meaningless. The AG's argument leaves Colorado judges without any authority to review sentences under the 8th Amendment. It's essentially tying the hands of judges. In short, the AG wants us and the 8th Amendment to be stuck in time, bounded by outdated draconian societal views on crime and punishment. The AG wants to double down on failed criminal justice policy, deterrence, and retribution, instead of recognizing the beauty of the 8th Amendment, which allows for courts to consider societal views that change as humans become more civilized and more humane. And finally, smart enough to recognize that we should follow evidence-based practices like treatment, rehabilitation, and restorative justice instead of policies that result in ineffective, expensive mass incarceration. The practice of judicially labeling certain offenses as grave and serious as a matter of law and thereby impervious to an Eighth Amendment challenge is unique to Colorado. And there's a reason for that. It's because it's unconstitutional. It's contrary to Solem versus Helms decision, the seminal case on Eighth Amendment proportionality review, which declares that, quote, no penalty is per se constitutional. The per se grave and serious label not only conflicts with Solem, but it also conflicts with the U.S. Supreme Court precedent that makes clear that the heart of the Eighth Amendment is the evolving standards of decency standard.
And so perhaps you could get specific and tell us which cases you'd like us to overrule.
I don't know that this court necessarily needs to overrule cases, but just needs to clarify the law a little bit more.
I thought you just said saying per se
yes,
grave and
so-
serious was unconstitutional.
Correct. Okay, so if you want to go down the route of overruling precedent, this court has actually, not until Rudder, ever used the label per se grave and serious. This court was very careful to just sort of suggest that as a matter of law, offenses were grave and serious. So what's sort of interesting is Gaskins was the first time this court sort of suggested a per se finding, but did not say that. And in fact, Gaskins is very consistent with Solem. It says that in that case, the theft, the second-degree assault on a police officer, and the other offenses at issue in that case were not so intrinsically grave and serious as to be, were not so intrinsically grave and serious. So it's actually consistent with the language from Solem that says that no penalty is per se grave and constitutional. Then fast forward to Cisneros, and Cisneros was the first time that this court sort of suggested that an offense could be considered grave and serious as a matter of law, not going from, not proceeding with the individualized determination that's the touchstone of the Eighth Amendment. So in that case, so Cisneros was the first time that it sort of got all mixed up, if that makes sense. Then subsequently, decisions continued to sort of apply Gaskins as though it was this as a matter of law designation. The Court of Appeals wholeheartedly embraced this per se grave and serious judicial designation and uses that language. So the problem is both in the Colorado Supreme Court precedent in treating it as a matter of law, and then in the Colorado Court of Appeals precedent as saying very specifically it's per se grave and serious.
And I take it the significance of the per se designation or the as a matter of law, whichever, is whether one has to have an extended review or simply could
So for the,
abbreviated review? What's the significance of the terminology distinction you're making?
yeah, excuse me for interrupting you. So the per se designation has been concluded by this court as rendering a sentence impervious to an Eighth Amendment attack, essentially. But there is this other piece of it that sometimes gets skipped over. So the Solem test says there's three parts to a proportionality review. What we now call, based on the rule of Harmlin, which was the plurality decision, that the first piece of that is the abbreviated review. That's Solem Step 1. And Solem Step 1 is a comparison of the gravity of the offense to the harshness of the penalty imposed. And when we do this grave and serious as a matter of law designation, often courts skip over that second part of the abbreviated review of the Solem first step.
But do you think our jurisprudence suggests that you can skip over the second part if you, simply because the crime itself is grave or serious?
Perhaps, I'm not sure what this court intended, but I know that that would be contrary to Solem versus Helm and contrary to U.S. Supreme Court precedent. So it's necessary at that first step of Solem to consider the gravity and seriousness of the offense as compared to the harshness of the penalty or the sentence. But effectively, it's been treated that once that per se judicial designation of grave and serious is attached to an offense, and it has frankly attached to as many, a lot of offenses. Most felony offenses have been labeled as grave and serious, which effectively means that trial courts just apply the law and say, oh, that's per se grave and serious, and then don't actually do any further review under the Eighth Amendment, which is a problem in terms of the U.S. Supreme Court precedent requiring an individualized determination. Does that answer your question? Okay.
Let me follow up, if I may. Were you going to ask something?
I guess I was just going to ask then, in response to the chief's question, are there specific cases that you say need to be overruled, given that your view is that this per se designation is unconstitutional?
Yeah, so Gaskins, like I said, doesn't say that, so Gaskins is good. Yeah, Gaskins is good, but everything thereafter where this court is suggesting, because it never says the per se piece, right? But suggesting that as a matter of law. So like in Cisneros, for example, relying on Harmlin and Gaskins' dicta, it says that narcotics-related offenses are grave and serious. I don't remember exact language, but the import is that grave and serious as a matter of law, right?
So everything Cisneros forward, essentially? Is that what you're saying?
When it says that, yeah, if it says that. And so the issue with the Cisneros decision is Harmlin doesn't say it's per se or as a matter of law grave and serious, because the United States Supreme Court has not adopted that framework. This is unique to Colorado. So Harmlin is not in opposition to the proposition, or Harmlin does not support Cisneros. Likewise, Gaskins does not support Cisneros because Gaskins was very much focused on saying that offenses are not so intrinsically grave and serious that you don't have to continue with the analysis.
Thank you.
So for instance, Duroulet, you think misconstrued Gaskins when it gave a list of crimes that would be grave or serious?
Well, I don't think, that's not the holding of De Roulet, so I don't think you guys need to, excuse me, this court needs to.
I like you guys, it's good.
I don't think this court needs to overrule precedent there.
Don't say
The
it
holding
some-
isn't.
As long as you don't say it's something like, you guys.
But if it's used, guys, and my cousin Vinny, Justice Moore's happy.
Anyway, back to our regularly scheduled program. Yeah.
Sorry, we sort of interrupted your thought in explaining why Duroulet was not a problem.
No, De Roulet, I mean, the holding in De Roulet is that for non-lifetime habitual offender sentences, you still are entitled to a proportionality review. So if we're looking at the narrow holdings of all these cases, I don't think you need to be overruling precedent here. We just need to clarify that under Colorado law and under U.S. Supreme Court law, you can't have these per se judicial designations or as a matter of law designations. But that doesn't mean that we're necessarily overruling a precedent if we're looking to the strict holdings of these cases, which are they're very informative about and guide this proportionality analysis.
Go ahead. Yeah, my question is whether our cert questions really encompass doing away with per se grave and serious or grave and serious as a matter of law altogether. I understood the cert questions to be narrower than that and focused on particular kinds of crimes. So help me understand why this larger issue is fair game.
Okay, so the two cert issues, as I recall them, were whether or not drug possession was a grave and serious offense, and whether or not theft was a grave and serious offense. And that's akin to the language that this court has used to suggest grave and serious as a matter of law. So I think those two cert questions encompass not only whether or not those two offenses are grave and serious as a matter of law, as well as whether or not they are grave and serious on an individualized basis, which is what I'm arguing is really the true test of the U.S. Supreme Court. So the cert issues do encompass this concept. You don't, I suppose, have to overrule the concept of judicial designations altogether, but narrowly within this case, you need to contemplate whether or not those are constitutional with respect to drug possession and theft.
If we we agree with you that drug possession and theft are not grave or serious, we don't need to reach that question then, would you agree?
True. Yeah.
Thank you.
Absolutely. Okay.
So if I can clarify, Ms. Porter Maryland, good morning to you.
Good morning.
I think the rule that you're asking for here would say that to decide gravity, you have to look at the individual circumstances consistent with Solemn. and I don't mean to be putting words in your mouth, but I'm thinking ahead, if we go here, what's the rule? It seems like you would say, to the extent this court or the Court of Appeals has adopted a rule that created grave and serious as a matter of law, that would be overruled or no longer good law.
Yes, that's much better than I would have articulated it. Thank you.
Okay, just making sure I was tracking with you.
Yeah. Okay, so turning to drug possession, and so we've already talked about the grave and serious as a judicial designation. I think that's important to note that Colorado has experienced a huge shift in public policy from drug use being proclaimed as evil to drug use being considered a public health problem to now we consider drug use to be a public health crisis. That's reflected in the legislative intent of the drug possession statute in Colorado, as well as 5 amendments to the drug and habitual offender statute in 3 years between 2010 and 2013. Under the facts of Mr. Melton's case, his drug possession convictions were not grave and serious. Applying the factors from Solem and Gaskins for an abbreviated proportionality review, in the triggering possession case, there was no violence. Mr. Melton cooperated with the police throughout the investigation. The absolute magnitude of the crime was minimal, as Mr. Melton only posed a risk to himself. He was originally charged with possession of a greater amount, but convicted of the lesser included. And Mr. Melton's culpability was minimal. Both the police and the trial prosecutor recognized that his possession amount was consistent with only personal use.
Ms. Portomaro, may I ask you something that I struggle with, just what it means. We mouth the words that you consider, I don't mean to say that disparagingly of my court, but we have uttered that you look at the triggering offenses in combination with the priors. How does that work? So in this case, you're articulating why the triggering offense wasn't grave or serious, and I understand that. How do we factor in a proportionality analysis the priors? So at least we've got a prior drug possession, a second-degree assault, and a theft, as I recall them. How do you weigh that? So let's say hypothetically, the second-degree assault was grave or serious. How does that weigh? I mean, how do we decide if there's gross disproportionality when we consider these things in combination? Do you understand what I'm asking?
I think so. Let me try, and if I don't understand, please ask again. So yes, Solem, as well as decades of this court's precedent, recognize that for habitual offender sentencing, we look to the triggering offense in combination with the predicate offenses. I don't think we can parse these pieces out. I also don't think we can parse out the first Solem, the first step of Solem, the whole abbreviated proportionality review. We have in Colorado sort of parsed it out as 2 different steps, 2 different subparts of assessing the gravity of the offense and then comparing it to the harshness of the penalty. And I think that parsing it out helps us think about it framework-wise, but really this is one big test, one comparative analysis about the gravity of the seriousness of the offense with the punishment. So then when we do that, plus the Solem and Colorado test for considering the triggering offense in combination with the predicate offenses, I think that it's the sum total. We need to be able to show that there is not a disproportionate sentence. So I don't think that one offense being deemed grave and serious is enough to defeat an Eighth Amendment claim. And I'd also like to point out that Mr. Melton's second-degree assault conviction was mitigated by the heat of passion sentencing mitigator,
Sure.
so it was an F6.
I understand. So let's say hypothetically, and I know this is not your case, you've got 3 offenses that were possession with intent to distribute, and let's say, hypothetically, they're grave and serious. So we got 3 priors like that. So we're looking at clearly a habitual sentence. How do we kind of decide, okay, here's what the habitual sentence, you started with the premise that Mr. Melton was looking at 2 years here, but 4. I think that presumes there's no habitual offender anymore, correct?
Correct.
All right, so let's say hypothetically, it was habitual. Do we look at the 6 years, say it was 3 times, it was the little habitual.
Okay.
So let's say it's 6 years. Is that what we're comparing to? And I'm sorry if I'm being dense here. I'm just trying to figure out how do we use this combination of priors and triggering?
I think Respectfully, I think this is a really tough question, and I think that it's something that is up for debate within this court. To my knowledge, there is no real great guidance on this, what that threshold is, what makes something proportionate. I know that the U.S. Supreme Court has talked about the difference between relative versus absolute proportionality, and I'm not sure I know the answer to that question, and I don't know that there's a lot of guidance out there for this court, but so you're, I believe, writing on a clean slate and can decide it how you would like.
All right, thank you.
Doesn't it come down to the discretion of the trial court judge that's reviewing it? Because it's the same thing in terms of comparing the gravity and seriousness of the offenses with the severity of the sentence, right? I mean, there's no mathematical formula. And so same thing here, when you're looking at the predicate offenses and the triggering offenses in combination to see whether together they are so lacking in severity, or excuse me, in gravity or seriousness that they give an inference or that they suggest disproportionality. It's not a 2 out of 5 or a 3 out of 5. It could be 1 out of 5 that's enough, right? 1 being grave or serious, depending on how grave or serious. It could be that you need more than that. So doesn't it come down really to, on a case-by-case basis and the trial court's discretion?
I think, Justice Moore, that that's a really good point, that this is about trial court's discretion or the reviewing court, because sometimes appellate courts review it for the first time instead of having the trial court do it for the first time. I think it's within the court's discretion, absolutely, to determine what offenses are grave and serious, and that is why the per se designation, the judicial designation, is wrong, in part. I also, I agree with you, the conflict or the rub might come about because this court has held that de novo review applies to a proportionality review instead of an abuse of discretion standard, but perhaps those individualized determinations are subject to abuse of discretion, and that could be clarified by this court. But yeah, that's certainly within the purview.
Can I ask a follow-up to that? If you do find that it's disproportionate, then what does the sentence become? Does it go right back to the presumptive range, or in this case, the defendant was sentenced to 24 years, correct?
Correct.
And if the judge said, well, if it was 12, which is well outside the discretionary range, could the judge do something between the presumptive range and what the habitual? I mean, I'm kind of getting at, I hate to see wildly inconsistent sentences to an extent.
Yeah, so I think that the Eighth Amendment, while it provides this framework, it can result in different outcomes because of the changing values of our society. With respect to how we address where the line for example, Mr. Melton's sentence becomes proportionate and constitutional, I think that's for this court if it decides all the issues at this level, or it's for remand to the trial court to decide what the appropriate sentence is. Again, there's very little guidance as to, do we have to do it now within the presumptive range? Do we have to do it within the aggravated range or whatnot? I see that I have about 7 minutes left. May I save it for rebuttal?
Could I ask you one question before you sit down?
Absolutely.
Tell me what you think the remand hearing looks like. So, yeah, just walk me through the remand hearing in your mind's eye.
Yeah, so the remand hearing, if we're following the rule of Harmelin, we're doing the extended proportionality review at that stage. We're doing an intra-jurisdictional comparison of the defendant sentences to other defendant sentences in the same jurisdiction. And then you do the third step of Solem, which is the interjurisdictional comparison, so the defendant sentences compared to sentences of other defendants in other jurisdictions, and I would say in Colorado that means other judicial districts.
So you're focused, oh, I'm sorry, Justice O'Gara.
No, I'm sorry, go ahead.
So your answer just focused on the extended review, but in this case, I think if we were to agree with you, we would also need the court to redo the abbreviated review because the court assumed per se,
Well,
or no?
I think that this court has acknowledged that this court is as well-positioned as a trial court to conduct an abbreviated review. So this court could do the abbreviated review. Alternatively, yeah, it could be sent back down for a new abbreviated review, applying the correct law and recognizing that an individualized assessment is necessary.
I'm sorry, Justice.
I know you want to save your time, but I want to follow up on Justice Hood's question. So you go back and you do the inter and intra, how do you do that? I mean, are you subpoenaing prosecutors and judges to talk about why they did what they did? I mean, it's really hard in the abstract to say this defendant as compared to this defendant.
Correct. So first, I think the extended proportionality review stage is very data-driven. And I think it's about pulling up sentences from that judicial district from other judicial districts and presenting that as an exhibit,
I mean,
for
only
example.
for possession charges, or would it be all sentences?
I think that it could be for possession charges. It could also be for, like in this instance, Mr. Melton received a 24-year sentence. That's comparable to a Class 2 felony in Colorado or a Class 3 felony with extraordinary aggravating circumstances, so sex assault on a child or second-degree murder. This is simple drug possession of trace amounts of drugs. There was a second point to your question that I wanted to
Well,
make,
I'm
but-
just trying to figure out how the evidence gets presented, because, you know, as a former trial court judge, there's so many nuances to sentencings in terms of, you know, I mean, you try to be consistent, but some possession is different than other possessions,
Absolutely.
especially when you're looking at a history and conduct and.
So you're grappling with what I think courts have grappled with since the proportionality test was announced. What is objective? And the most objective factor, as Justice Stevens said in Atkins versus Georgia in the majority decision, the most objective factor the U.S. Supreme Court has recognized is changes in legislative policy.
Thank you.
With that, I would like to request.
Other questions before we allow counsel to reserve?
I have more, but I'll let her sit down.
Okay.
Go ahead, that's fine. Good morning. May it please the court, William Kozlowski, registration number 37824 on behalf of the people. I just want to start with, Ms. Portomero said several times that the touchstone of the Eighth Amendment is an individualized sentencing determination. The majority holding in Harmelin that was joined by 5 members of the court was that a defendant is not constitutionally entitled to an individualized sentencing determination under the Eighth Amendment. The rest was a plurality. That is the holding of Harmelin. So
Unless it's a death penalty case?
yes, that's probably true. I'd like to start with 2 points. First,
Let me jump in on that,
sure,
Mr.
yeah.
Kozlowski. Just a
It's
thought.
easier.
So I understand what you said, but there are also plenty of Supreme Court case law that says there is no sentence that's per se constitutional.
No,
So
that's-
how does that square with our notion of grave or serious as a matter of law?
I think the genesis of this court's per se classification was the original habitual criminal statute, which gave life with parole after 40 years. So this court said, okay, in order to do the abbreviated review, if we have a certain type of offense, that's the triggering offense, that should be the focus, and then we have the prior offenses, and those include, the language of this court is, those include grave or serious offenses, then the life sentence, going to the second step, is not disproportionate. So I don't think it's that a sentence is constitutional as a matter of law. It is, we have Supreme Court precedent of what is proportionate, and that's how we judge things going forward. It's not just every case we judge on its own merits. It is, we have the bounds of the 4 cases from the United States Supreme Court, and where does this case fit into that? And I think in Rudder, this court said, well, his triggering offense was manufacturing methamphetamine. In Harmelin, the U.S. Supreme Court said that offense can get life without parole as a first offense. So it doesn't really matter what the other three were, because he could have just gotten life for this offense. So we don't need to analyze anything more. And if I could stress one thing that I would urge this court to do is the analysis. I think, Justice Gabriel, you asked, like, how do we weigh this? And her answer was, well, I don't know. Well, there are two answers there. You can judge it by the 4 U.S. Supreme Court cases, because those are the cases that this court is bound by. And if you don't know, then Harmelin provides the answer to that. The answer is you defer to the legislature if you don't know.
Well, help me with that, and thank you for going there, because I've struggled with this since my years on the Court of Appeals, what this means. So just give me specific examples. Let's take, you got 3 prior offenses for possession with intent, but the triggering offense is simple possession of a microscopic amount of, methamphetamine. How do you weigh those to decide whether it's just the sentence is grossly disproportionate?
Okay.
Where do you start? What's the analysis?
Well, I think you can start with Harmelin and Justice Kennedy's discussion of the societal harms that come from drug possession and the distribution of drugs.
So are we looking at all 4 of those convictions?
Okay, I see what you're saying. I guess my first answer is a first offense for drug possession, simple drug possession, is less serious than your 4th felony that is simple drug possession. That is more serious because it is your 4th felony. And then you look at the harm to a victim or society. And then I agree with Ms. Porter-Merrill that a lot of Court of Appeals cases skip over the second part. And I think that this court should return to not skipping over that part in a lot of cases, because under the old statute, you got life with parole. And as recognized in Deroulet and Close, the legislature redid the statute to control for the severity of the triggering offense. So it was rare under the prior offenses where you got life. It is even more rare now because they always have controlled for the triggering offense. And as an example, Your Honor, it's sort of a strange example, but it's one of the first cases I had when I got this job. The defendant had a habitual sentence for indecent exposure. And to get that sentence for indecent exposure to be a felony, you had to have 2 prior indecent exposures. And then he had all 3 of his felonies were indecent exposures, and he got 6 years. And the public defender's brief was about grave or serious, and my brief was about grave or serious, and the Court of Appeals opinion was about grave or serious. But my reaction to it was, he has 3 felonies that aren't that serious, but he only got 6 years, and he's eligible for parole after 3. So grave or serious doesn't really fit into that. And I think that's the case here. I mean, my position on grave or serious is in the brief, but this case just comes down to, you have Hutto where the defendant got 20 years for possession with intent to distribute as a first offense. It's like, okay, so Mr. Melton's triggering offense here is not that serious, not as serious as that. You have Rummel where, in today's dollars, the defendant stole about $700, and he got life with parole after 12 years. And then you have Ewing, and I would urge this court has never dealt with Ewing. And we mention Ewing all the time at the Court of Appeals, and it seems like that is the most recent pronouncement from the court that this court is bound by. It's bound by the result. In that case, he stole $1,200 worth of golf clubs, had 2 sort of serious priors, and he got 25 to life. And that was 25 to life. The minimum was 25. So here, maybe his triggering is not quite as serious as theft. Maybe, I think that's up for debate. One of his priors is serious, I think without question. He stabbed someone. Theft was the triggering offense that Justice O'Connor says is not lacking in gravity. And then his other offense is possession. So it's, okay, so what sentence did he get? He got 24 years. But and I think Justice Breyer has it right in the dissent, there was like, you need to look at the actual time he will spend in prison. So he's eligible for parole after about 10 to 12 years. I think it would be an odd result under a recidivist statute to make an inference of gross proportionality where the defendant could get out on parole before his direct appeal was over. And just so this court knows, I mean, the defendant is currently in community corrections. He's not even in prison. So Colorado has set up a system where he gets an admittedly long sentence, but the sentence of 24 years is misleading to a certain amount. It's not, he doesn't get out for 24 years.
Mr. Kozlowski, as a former trial judge, you give me a little bit of a headache to weigh all these factors about comparing it to different offenses and ultimately where he might serve. I mean, I can recall doing a dependency and neglect case where a guy was convicted of assault, given 12 years, and 3 years later, he was living in an apartment at home. I mean, there are so many variables. Is echoing what I said to Ms. Porter Merrill, I am so worried about just wildly divergent circumstances.
Your Honor, I think that gets to the heart of it. Rummel talks about this. There are so many variables that go into this decision, but that's why the rule is you defer to the people across the street.
So then when is there gross disproportionality? I mean, you say as long as the sentence, applies with the literal words of the habitual statute, that's the end of the story. But that would seem to read the Eighth Amendment out.
That doesn't read the Eighth Amendment out. That means that U.S. Supreme Court precedent has held that virtually all term of years sentences are constitutional. And I mean, that's what they've said.
So there would never be an Eighth Amendment violation on a term of years sentence.
The precedent says you still have to go through the analysis, but under the structure of our habitual sentence, where the triggering offense is always controlled by the severity and their judgment of how serious that crime is. I mean, the reason I filed a supplemental authority in this case, and the reason was not because it's groundbreaking or anything, but that case says we have never found a term of years sentence to be unconstitutional, and it is just a discussion of there are these cases from the U.S. Supreme Court. This fits in with those cases. I guess I'll go back to this court said in Hernandez, which is, I think, the first case dealing with a habitual criminal statute, the only way to distinguish Rummel from Solem is that the defendant was eligible for parole.
So ultimately, you're telling us that the problem against which this guards, this whole scheme, really can't come to pass under Colorado law as it currently exists.
It would be a very rare case. I don't want to say it couldn't happen, but
as you've tried to think about hypothetical scenarios in which it could happen, have you been able to come up with any?
I mean,
under
I
Colorado?
think you could. I think you could come up with maybe one that involved if say four. Well, maybe I should say I've never thought of one. I mean, yes, it is tough. I guess I'll just fall back to U.S. Supreme Court precedent. Rummel was theft of, the triggering offense was theft of $700 in today's dollars. The priors were theft of $700 and theft of $100. And that guy got life. And this court is bound by that decision. So I mean.
So if these were all PCS offenses, just straight possession, no distribution, no manufacturing, and it was under the old law when, say, the PCS was a 4 and you got max with under the scheme, even under that scenario, there's no proportionality problem in your estimation? Even
No.
if we were to say all of those offenses don't constitute per se.
That's for purposes of my case, that is what I want to drive home. We have all this grave or serious analysis, and that was meant to be a shortcut for a life sentence for judges doing that analysis. And when they redid the habitual statute, let me put it this way. Our position in Derelay was, you don't even have to do this anymore because of what the legislature did. And this court said, no, you still have to do it, but we are very confident that pretty much every sentence will be fine.
So,
Well, go ahead, please.
I was just going to say, so under your theory, we can do away with the grave and serious.
I don't
We
think you need to do away with it, because it can come into play in cases like Rudder, where it is essentially a life sentence, and if it is a grave or serious offense, then you don't have to go into the facts of that offense. And going to,
Can I
Oh,
interrupt
sure,
you
yes.
just 1 second about the grave or serious? I guess I'm not tracking entirely when we talk about whether one could do away with grave or serious. If with regard to the first step in the determination in Kennedy's test in Harmelin, we were to determine that a crime was not grave or serious, would it be subject to an abbreviated review at all?
oh, yes,
And how would that analysis go?
well, then you look to the facts of the case and how serious it was. In this case, this court has done that.
So we look to the facts of the case, and what if we decide based on the facts of the case it's not grave or serious? Where does the analysis go?
Well, then you say, okay, this was not that serious. What's the sentence? And if the sentence,
Don't we do that anyway, even if it's grave or serious?
this court has. I feel like the Court of Appeals skips that step. They seem to think that if things aren't grave or serious, then there is an inference of gross proportionality. They have skipped over the what's the sentence part. Going to cases you'd have to overrule, the main case you'd have to overrule is Cisneros, and that case is almost on all fours with this case. The defendant, it was not the defendant Cisneros, it was Mr. Yates. He was convicted of possession. His priors were possession with intent to distribute, menacing, and violation of bail bonds, I think. And this court held that his life sentence with parole eligibility after 40 years gave no inference of disproportionality. So even if there has been some societal progression on how serious we view drug offenses, then defendant's 24-year sentence doesn't give rise to any inference.
Well, if I can kind of lead you to maybe your heading here. So explain to us why in your view, we don't even consider legislative changes. I mean, the legislature changed some of these drug possession statutes and specifically said you don't consider them anymore in the habitual analysis. Likewise, theft, depending on the amount of money, is, clearly not, a very low sentence. And you say we don't even consider it. You agree that retroactivity is a different question than proportionality. I'm having trouble understanding why we wouldn't at least consider at the day of sentencing that the legislature has changed all the sentences and specifically said you don't consider this one in the habitual analysis anymore.
Well,
Why would it be fair to say one defendant on the day before the legislation takes effect is going to get 24 years and then the guy the next day is going to get 2?
Okay. My first answer is you don't consider it in abbreviated. It's in extended. And the cases that all the Court of Appeals cases cite is Penrod. And that was the first case to say it, and that's an extended case. And so was the Court of Appeals Gaskins case. So that's...
But you, I think, also argue that you rarely get to extended. So, it seems
Right.
to me that in reality, under your analysis, we really would never consider the legislative view at all.
That is probably true. this court doesn't have to go looking for an Eighth Amendment violation. Just because all the sentences aren't disproportionate in Colorado, that's okay under U.S. Supreme Court precedent. You don't have to find one. But to go to your prior question, I think my main answer is it's part of extended. And to follow up on that, it is what does this court consider in its cases when it's discussed grave or serious? What has it considered when you concluded that possession was grave or serious? You didn't cite the statute. You didn't say, well, the legislature thinks this is serious. You cited Harmelin and Justice Kennedy's discussion on why drug possession is a serious problem that affects
But don't,
society.
and I'm sorry to interrupt
that's
you,
fine.
but don't, I mean, mores change over time. In, the 1980s, I guess it was, we had the war on drugs, and that was a big deal, and we put a lot of people in prison for a long time. There's at least an argument that society's changed, that we're imprisoning too many people who just are addicts.
Okay.
And so why do you not get to, so I hear what you say, and I agree with you that Harmelin did say that, but why don't you get to consider a change in societal view?
Well, I guess let me answer it by skipping to an argument of, let's assume you do consider it. The overarching value in all of these cases is that this court should defer to what the legislature did. Well, after Stellabot, the legislature made a conscious decision to keep those sentences in place. So that is as much a legislative judgment that is entitled to deference as any other legislative judgment. And I think the other part of your question that goes to, I think, what the heart of what the defendant is arguing here is, she said many times, the policy change. I agree with that. It's a policy change. It is a legislative judgment that deterrence and incapacitation should give way now to rehabilitation. It was not any sort of comment that the crime itself is less serious. And let me give you an example. Let's say in 20 years that they have, they've come up with a great way to treat sex offenders. And the legislature changes sex offenses to F5s and says everybody gets probation in this great new rehabilitative treatment that we found. You wouldn't say that the sex offenses were not serious. It's still just as serious. It's just they have made a legislative judgment that a different theory of punishment is better. And I think that is demonstrated in the legislative declaration, 1818-401. It says that treatment is an effective alternative to incarceration, an acknowledgement that incarceration, that to me is a viable option. And it says the savings from less incarceration should be used for treatment. That says nothing about how serious the crime is. It is the legislature trying to use our limited dollars more wisely.
So help me understand, though, having made that determination, why should a sentencing court nonetheless disregard that legislative decision and go ahead and incarcerate that person for some lengthy term of years? I mean, it seems to me that telling a trial court that just because the legislature has commanded going forward, drug offenders shall not be incarcerated, that for this particular defendant, the court should disregard that and nonetheless go ahead and incarcerate that person for a lengthy term of years. I guess I struggle with how you are giving, how you're honoring that legislative determination.
Because, I'm not trying to, that's their choice. That's not the judge's choice. They can say, maybe this is the answer to your question. A legislature is entitled to take both roads. One road can be, we're going to deal with the drug problem with deterrence and incapacitation and put people in prison for a long time. Or we can do treatment and less incarceration. Here is the day where we're going to switch. Just because they switched doesn't mean that there is an inference of gross proportionality to the prior one. They're both, they can do either thing. Maybe, and under her position, you can't go back. If this court holds that his sentence leads into an inference of disproportionality, the legislature can't go back. I mean, the drug problem could explode, and the legislature can say, hey, we need to throw all these people back in prison that are repeatedly doing these drug offenses, and they will go to a trial court and say, nope, you can't do that anymore.
I guess I'm not following that, because if the legislature were to increase penalties going forward, you're saying that a court then, under her view, having previously found that it was grossly disproportionate, couldn't sentence someone in conformity with the legislature's new determination?
Yeah, that's, I mean, it will be, this sentence violates the Eighth Amendment. The legislature is constitutionally precluded from imposing this sentence.
So I guess I'm just struggling with who gets to decide this, because it sounds like you're saying the judges basically get to draw from their own experience and decide X or Y is grave or serious, irrespective of what the legislature has determined. I find that a little bit troubling.
I mean, that's what this court said in Rutter, is that judges decide what is grave or serious, but
without reference to anything, without reference to the legislative determination.
To the, whatever Solem says, the culpability of the offender and the harm to the victim or society. And I mean, there's and I'm not meaning to be glib here, there's a reason Justice Scalia said this is a standardless test that can't be applied. We all struggle with it, but it's here. So, and maybe I'll return to, if you're not sure, then it's constitutional.
I think Scalia didn't win in that case.
No, that's true.
Isn't there case law that says that one of the things that we can look at in determining the evolving standards of decency in a maturing society is legislative changes and policy changes
Sure.
made by the legislature?
And I think that goes to my argument of these legislative changes are not any sort of judgment on the seriousness of the offense. And I think the case is called Humphrey out of Georgia that Judge Berger relied on in my case. And in that case, the defendant was convicted of child molestation, and he was 17, and it was consensual sexual activity with his 15-year-old girlfriend. And subsequent to his offense, they changed it to a misdemeanor and took it out of sex offender treatment. And the court there said, this legislative change evinces an intent that society doesn't think this is a serious crime anymore. It wasn't that he needed more treatment. It wasn't some other theory of punishment. It was just that it was not that serious. And that's not what we have here. This is still a serious problem. I mean, it's uncontrovertible that the drug problem is a serious problem. It is that there are different ways to deal with it.
Counsel, don't the different ways to deal with it in the context of possession go to culpability, that the recognition that addiction eliminates some of the culpability that we used to attach to the use of drugs?
I think that's part of it, but I also think that it doesn't overcome the potential harm to society when the person is repeatedly doing it. I mean, we can all think of cases where a person who is a mere addict or does something terrible because they are a mere addict. And that is what Justice Kennedy's talking about, that legislatures are entitled to try and prevent those harms by punishing just drug possessors. I mean, let me answer your question this way. I think the drug problem is unique in the sense of you have arguments on one side saying we need to punish this criminally, we need to punish it seriously. If people do it over and over again, we need to put them in prison for a long time. And on the other side, you have people saying we should just make this all legal and forget about it and regulate it. And my position is all those options are okay. That's for the debate across the street.
Right. Right, and I agree with you about that. I'm just in sort of thinking about, and this may particularly go to whether we can think about legislative changes in the abbreviated review. If in the abbreviated review, we're looking at culpability, and the legislative determination that addiction, that treatment is a better option may in fact speak to something about culpability, maybe that is the place that we ought to be looking at that legislative change.
If you were going to look at that, and if you conclude that you can look at it, I don't dispute that that would be part of it. I have 1 minute left, and I want to make one quick point. There's a statute here that no one has talked about, and to me, it demonstrates that the legislature has made a choice to continue to punish drug offenses as serious offenses under the habitual statutes, 18.1.3, 8013. That statute has been there since, well, I stopped in 1989. I'm not sure if it was there before 1989. And that is, no drug law shall be counted as a prior felony unless it's not a felony anymore. So the concerns that you have or that my opponent has about how serious this is, that statute specifically deals with that. And I think that is a recognition that part of the deterrence of the habitual statute is when you are convicted of a felony, you know it's a prior, and going forward, if you commit another felony, that may be to your detriment. And unless it is not a felony anymore, it can still be used, even with the prospective legislative changes. I'm out of time. Thank you.
I think the most important part about this case is that the heart of the Eighth Amendment is incorporating those evolving societal views. And the evolving societal views encompass, as Justice Moore said, legislative policy changes, as well as the historical conceptions of crime and punishment and international law, as the U.S. Supreme Court has said. The U.S. Supreme Court cases that the AG cites, he said that the court is bound by the results of the United States Supreme Court cases, and I disagree. This court is bound by the law of those cases, is not bound by those fact-specific determinations about proportionality review analysis, and that is exemplified by the fact that policies do change, and there was the war on drugs, and so Harmland may have been appropriate at that time. And speaking of that, Ewing was at the same time, and in Ewing, the legislature had not actually changed the policies in the state of California at that point. And so the U.S. Supreme Court was pointing to, if you have a complaint about the length of these sentences, your complaint needs to be directed at the legislature because you need to change those laws. And then once those laws have been changed, then the Eighth Amendment can be effectuate that policy change, those evolving societal views.
Can I ask one question about that? So would you be saying it's always a violation of the Eighth Amendment for the legislature to dramatically reduce a sentence for a crime and not apply it retroactively?
I think that's up to the courts to be determining. So as Justice Stevens said in Atkins versus Virginia, a claim that punishment is excessive is judged not by the standards that prevailed at the time of the Bill of Rights or at any other time, but rather by those that currently prevail. And so it's up to the courts if they if the courts consider this as part of the evolving societal views change, to then effectuate those
So the
policy
reduction in sentence by the legislature doesn't indicate that it's a changed standards of decency at all. That's up to the courts to decide. Is that what you're saying?
I think that that is what the Eighth Amendment contemplates, is that the courts are considering the evolving standards of decency and the evolving societal views, and one way to consider those evolving views is to look at those policy
Would that
changes.
seem to suggest then that we should, without regard to any change in sentencing by the legislature, always review its sentences with regard to whether they are still consistent with standards of decency?
I think that that's what Ewing suggests, frankly. I think that when there's a policy change, then we can effectuate that through the evolving societal views standard.
It does seem like we're circumventing the retroactivity problem by using the Eighth Amendment. You know, Mr. Kozalewski makes a good point, right? The legislature decides that they're not going to make this retroactive, and then we use the Eighth Amendment just to say, never mind that.
Okay, so Mr. Kozalewski says that the legislature made a conscious decision, that's throughout his briefs as well as in his argument, to make that an effective date. I have worked enough with the legislature to know that that is a ministerial decision. That is not about the substantive changes. We need to be looking at the substantive changes. That's the policy decision. That effective date is just for logistical purposes. And I actually think that there are 3 different vehicles to obtain retroactive relief, but that's an issue for another day. Mr. Kozalewski also suggests that term-of-year sentences can never be disproportionate under the Eighth Amendment, but that would be in contravention of this court's decision in De Roulet that does consider a term of years habitual offender sentence. The heat of passion, second-degree assault, there were also mitigating factors of provocation, and the victims were provoking Mr. Melton. I see that my time is up, and I would just ask this court to reverse the Court of Appeals decision, vacate his sentence as unconstitutional, and remand to the trial court for resentencing. Thank you very much.
Thank you.
Thank you.
We appreciate the arguments of both counsel. Case is going to stand submitted, and the court's going to take a recess for 10 minutes.
Court is in recess until 10:15.
Thank you. Please be seated. The second argument we've got set this morning is styled Wells-Yates v. People. We've also set this one for an hour. If both counsel are ready, counsel for petitioner, you may begin.
Good morning. May it please the court. My name is Dana Weiss, registration 36656, and I'm here on behalf of Ms. Wells. Just to briefly recap, the U.S. Supreme Court has stated that no sentence is per se constitutional, and the proportionality question is one informed by evolving standards of decency that mark the progress of a maturing society. And the import of the Eighth Amendment and its applicability must change as the basic mores of society change. With these principles in mind, Ms. Wells asks this court to announce today, 1, that it will no longer declare narcotics-related offenses as grave and serious as a matter of law. 2, instruct lower courts that they can and should consider legislative changes in a proportionality analysis. 3, reaffirm that when conducting proportionality analysis, courts are to look at both the triggering and the prior offenses in combination and in relation to the harshness of the penalty imposed in a proportionality analysis. And 4, she asks this court to apply these principles and find her sentence raises the inference of gross disproportionality because the only reason she received a 72-year sentence to prison is because she had 3 prior drug convictions from the 1990s. I wanted to touch on a couple of things that obviously were addressed earlier, but one reason that there is a disconnect between our courts and the legislative approach to drugs is our per se approach to declaring broad categories of crimes grave and serious in Colorado. And I just wanted to touch on the fact that when I traced this back through the Supreme Court, in Cisneros, there was a discussion about a de novo review of the proportionality of the sentence in that case. And part of that review, the court indicated that it reviewed Supreme Court cases and other cases by this court. And those cases had held that narcotics-related offenses were grave and serious. So it stated that. It didn't say as a matter of law, therefore they are always per se grave and serious, or as a matter of law that they are grave and serious. However, in Derelay and Close, that is when the court articulated the per se standard that lower courts now apply. And I just wanted to make sure that I highlighted that, and that is that in Derelay, this court indicated or wrote, quote, "We have delineated certain crimes as grave or serious for proportionality reviews. When a crime is grave or serious, a reviewing court may proceed directly to consider the severity of the punishment. Some crimes have been determined to be grave or serious for purposes of proportionality review, thereby negating the need for utilizing Solom's considerations to make such a determination." That's what this court said. So essentially, as a matter of law, these are per se grave and serious offenses, and that's at Penn Site 524. In Close, the court stated, "A Colorado-specific principle includes articulating that certain Colorado crimes are grave and serious for purposes of proportionality review. The result of our delineation of certain crimes as grave or serious is that when these crimes are involved, a sentencing court may proceed directly to the second subpart of an abbreviated proportionality review, a consideration of the harshness of the penalty." And further, that this results in a near certain upholding of the sentence. So those two statements in combination, and they were companion cases, that's how we get to the per se designation today. And I'll note that if you look to Westlaw, there are about 20 Court of Appeals cases that have articulated this principle as the per se approach. So that's what we're asking the court to revisit in light of. That's why we're here today, essentially. Courts just listen to the fact that, well, this has been considered a per se grave and serious offense, and that forecloses any further meaningful review under the Eighth Amendment.
And could I ask perhaps, so would you articulate how you believe the determination of grave or serious should be made?
Yes, I think the Solon v. Helm gives guidance to exactly what the courts are supposed to be doing. They're supposed to be looking to objective factors in considering the relative seriousness of the offense. And in so articulating that principle, they say that they trust lower courts are able to make this determination of the relative seriousness, that an attempt is necessarily less serious than a committed or a completed crime, that a lesser included offense is necessarily less serious than a greater included.
Those factors have to do with the crime itself, though. And I
Right.
take it your objection is to calling something per se grave or serious based on the nature of the crime itself, as it's defined.
That's correct.
So we should look to something else. Are you saying look to the facts of how it was committed in this case? What are you saying that would
Well-
be different from what we've said in the past?
Again, looking to the Solon factors, and part of that is consideration of the motive. I mean, they outline various factors that a court can consider in an individualized assessment of a particular sentence that a lower court is looking at.
Do you think that, I'm sorry, do you think that in articulating those factors in Solem that the court was directing, SCOTUS was directing trial courts to examine the particular facts in a given case, as opposed to just categorically the crime as defined?
Yes, I do. I want to qualify that as it relates to the conviction itself. Yes, I think that it's supposed to be directed by objective factors, such as the relative seriousness of the offense committed versus attempted versus a crime involving violence, the motive of the defendant. That suggests that they should look at the facts as well. This court in Gaskins and in Cisneros and in Mershon talked about the various factors that a court can consider also. And it was a non-exhaustive list. I think they explicitly state that in Cisneros, or you explicitly state that in Cisneros, that it's a non-exhaustive list, but it involves a weighing of the relative seriousness based on the Solem v. Helm factors, based on the motive, based on whether violence was involved. That's another consideration.
But let me stop you right there since you say violence was involved. Do you think then there are some crimes that by very definition we could tell are grave or serious? Would it be fair to say first-degree murder is a grave or serious crime?
Well, first-degree murder, we wouldn't be in this position because it's a life without the possibility
I'm
of
trying
parole.
to narrow how you want to
Right.
decide whether you're saying we should throw out all designation of crimes as being grave or serious simply on the definition of the crime?
I do believe that we should throw out the per se approach. And I say that because it's contrary to United States Supreme Court decisional law. There has never been a U.S. Supreme Court case that has adopted this per se approach. It's contrary to Supreme Court decisional law because it directs specifically that it is an individualized, meaning, when I say individualized, I mean particularized to the circumstances, not to be confused with the individualized doctrine. It's particular to the circumstances present before the court.
So would you be saying then it would be improper for us to say the defendant was convicted of first-degree murder? That's a grave or serious offense. We should have to look at the circumstances by which he committed the first-degree murder?
I don't believe that that's true, but it needs to be, the facts need to be present before the court to say, this is a first-degree murder. We are finding that because somebody died necessarily by the elements of that offense. And there's no mitigation. There's no higher offense that the person could be convicted of. That's enough to say that this is a grave and serious offense in this instance.
And so would it only be something that was a first-degree, class 1 felony, first-degree murder? I mean, is it that there could be no higher crime that makes a determination? I guess where you see I'm going is, it seems to me our prior cases can be read, whether they've gone too far or not, to say there are some things that it's unnecessary to look at how the particular crime was committed, the facts of the individual case, because we're going to find that, given the elements, that always is going to have to constitute a grave or serious crime for purposes of abbreviated review, and that's what we're talking about, I guess.
I think that that's contrary to Solon v. Helm and the proportionality question that's supposed to be present, or that can be analyzed in each individual case. I understand your inclination that, I mean, there must be some cases or some crimes that are just so on their face and by their elements, necessarily grave and serious, and first-degree murder is a great example. But I don't think that it's necessary to say it's per se. I think that courts can say in this instance this was a grave and serious offense, not that it should foreclose any further review of, for future cases and throughout time.
All right, thank you.
Let me ask you a question that Justice Hood asked in the last oral argument, but I'll ask it with a different accent than he did. So do you think the question about whether we should get rid of the per se label is before us? Is that a question that we should be looking at, or is it narrower than that?
No, I acknowledge that I actually presented that as a question, and it was not accepted as a cert question. I bring it up only because it informs the analysis and why we are here today and what happened here in terms of we have this massive change to our drug laws. And that is, if you listen to the legislative history for the 2008 or 2013 drug law changes, they are talking about how they want to change the nomenclature. We don't even want to call these things felonies. We don't want people to go around with a felony conviction. We're going to call them drug felonies because they are a different beast altogether. And we're going to minimize the sentences that people are facing. And we're going to change virtually every aspect of Title 18 to reflect this entirely different approach, penological approach, and making it rehabilitative to make these massive changes. So we have this seismic shift in our drug laws, but courts are unable to consider that or account for that or evolve with that because of the per se designation. And that's why we are here ultimately.
And so in the habitual criminal context, would you then be advocating for the same type of analysis with respect to the predicate offenses? In other words, that let's say somebody has predicate offenses that are narcotics-related crimes. With respect to each of those, you'd be looking at all of the solemn factors that you talked about earlier to determine whether each offense or taken together, they're grave and serious.
That is correct, and that's in line with almost 40 years of precedent in this state, as well as under U.S. Supreme Court case law, decisional law, again in Solon v. Helm, that you look at all of the offenses in combination. That goes back to People v. Hernandez in 1981 by this court, as well as in Gaskins, as well as in De Relay. I think it was repeated in Close that courts, when considering the proportionality question in the habitual context specifically, must consider all offenses, plural, in combination when they are assessing the proportionality of a sentence. So yes, I do believe that that is necessary, and in particular, that is Ms. Wells's situation, because she has just the 3 prior drug offenses.
If I can ask you to, same question I asked both counsel in the last argument, walk me through how that works. And this goes to the Rudder issue presented in this case. So just physically, how do you do this analysis? Walk me through the analysis of looking at both in combination. What do you look at first?
Well, I think that, again, the spirit of like Solon v. Helm and the Eighth Amendment is that we trust trial courts to conduct this analysis. And I think that also in Cisneros, Gaskins, this court talked about deferring to the court's determination of what information is appropriate to consider, the extent of the information that it needs to inform an appropriate Eighth Amendment analysis. So there's a lot of, leeway for the court in that sense. But I think that the court needs to look at the triggering offenses, certainly, why the court or why the defendant is there, and assess the gravity and seriousness based on the factors in Solon v. Helm, based on the factors in Gaskins, Cisneros, and whatever other information. I think this is key, too, because in Gaskins, the court talked about either the sentence kind of on its face gives rise to an inference of gross disproportionality, or based on any other evidence presented by the defendant to make that determination, has to determine whether the sentence is grave and serious, and then in relation to the harshness of the penalty. So you look at the triggering offenses, and then you also look at the priors.
So let's say, for example, and this is a hypothetical, you have a violent assault, somebody stabbed, somebody's hurt, is your triggering offense. And then there are some, say, simple possession, 3 priors. Could the court say no inference of gross proportionality based on the triggering offense alone? And say, I'm not even going to I don't even need to look at the priors here because the triggering offense alone was grave or serious, and that leads me to conclude no inference of gross disproportionality.
I understand that that's what this court did in Rudder, essentially. I mean, not with the assaultive behavior, but determining that the triggering was per se grave and serious, essentially, and therefore not even reaching or looking at the prior convictions. And I do think that that was not in line with prior decisions.
That's why I'm asking the question, so help me understand.
So I do think that, I think Oldright gives the court great guidance, the Court of Appeals decision that was recently decided, because that was a triggering offense in which I can't remember what it was, but it was an assaultive behavior, I believe, a first-degree assault, perhaps. And then the priors were so minimal that the court determined that it did raise the inference of gross disproportionality and then remanded it back. So I think that you can determine, okay, the instant triggering offense is grave and serious, but we have to consider that in light of the prior offenses too, and then consider whether the sentence received is grossly disproportionate. If you are, for example, like Ms. Wells-Yates, receiving a 72-year sentence for the crime of burglary and possession with intent, which should be 64 years, and the offenses that she had, why is that's pretty disproportionate, given that ordinarily a burglary is legislatively determined to have a presumptive sentence of 4 to 12 years. So.
All right, so in my hypothetical, by way of, and I will just make up a sentence, say the assaultive behaviors in that case, my hypothetical is going to get you 6 years, but because there's a habitual offender, because of 3 possessions, it becomes 24 years. You would say that's how you weigh it in. You're saying you got 24 years here for what would have been a 6-year offense based on these priors that were fairly minimal, and that leads you to an inference of gross disproportionality. That's how it fits together?
It can, yes. Yes,
Okay.
that can be one way of resolving the issue.
All right, thank you.
In this case, Ms. Wells-Yates' priors were not, we should talk about what the specific drug crime was, right? It wasn't possession. It was possession with intent to sell.
In 1995, she had a possession with intent. In 1996, she had just simple possession. In 1999, she had a simple possession.
And then in the triggering case, she was convicted of possession with intent.
Yes, after she was arrested, they searched her car. They found very minimal amounts of methamphetamine in her personal belongings, her purse, and then throughout the car. And because there were baggies and a scale in the car as well, it was charged and she was convicted of possession with intent as inferred by those circumstances. So it was a possession with intent in the current offense as well.
And so in Rudder, we specifically noted that the legislature, although it changed sentences for possession and use, it didn't for sale of drugs. Should we take that into account in thinking about Ms. Wells-Yates' case?
I respectfully disagree with that aspect, because Rudder actually does address the same sort of offense as Ms. Wells. So for example, she has a possession with intent. That's under 18-405, so is manufacturing. They're all under the same statute at this point. But the laws did change as to those. Those were 4 to 16-year sentences at the time of each, I believe in Rudder's as well, but certainly Ms. Wells' case, 4 to 16-year sentences. That was the presumptive range. The 2013 legislative changes to our drug laws rendered those DF3s for the maximum sentence that she could have received just a few months later for that same offense was 4 years, the maximum in the presumptive range for the DF3, which that became. So the manufacturing in Rudder and the possession with intent in this case as well, those laws did change. They became drug felonies, not felonies any longer, and they became subject to a presumptive range of 2 to 4 years. So I do think that that is something, again, that can be taken into account on an abbreviated proportionality analysis. I understand that there may be some language in these changes that it is primarily aimed at addicts and users, but it didn't only apply to those circumstances. It was an entire reworking of our drug laws. And I think that's evidence, and that's why I attached Senate Bill 13250 to the reply brief. You can really see the expanse of what they were doing there. You can also go back to the legislative history that's online and listen to the way that they were couching this, and that was that we are changing everything that we know and do and how we approach these drug laws.
Ms. Wells-Yates was also convicted of burglary and conspiracy to commit burglary as well, right?
And again, any meaningful analysis was foreclosed because because the court found, well, it didn't explicitly say this, but this court has found that burglary is per se grave and serious, or as a matter of law, grave and serious. And so it foreclosed any further meaningful analysis. I think that that's wrong as well. I think that a proportionality analysis needs to take into consideration the relative seriousness of the offense pursuant to Solon v. Helm. And when you look at that, when we started declaring burglary offenses as per se grave and serious, those, I think it's in De Relay, that was a first-degree burglary case. By its nature, it involved the threat of violence, because to commit a first-degree burglary, you have to either have a weapon or you have to assault somebody. The commission of an assault, I believe, is required as well. That's a first-degree burglary. So that court states that's a serious, grave and serious crime. And then after that, all burglaries are per se grave and serious. And in Colorado, we have third-degree burglary, which is burglary of a coin-operated machine. So if you go, you see a chip hanging off the burglary or at the coin vending machine, and you shake it, that could land you in court on a burglary, and then you're in front of a court on a proportionality analysis, and the court would say, I'm sorry, these are per se grave and serious crimes.
Are you aware of any situation in which a third-degree burglary has ever been treated as a grave or serious offense for purposes of habitual criminal?
Yes.
You are?
I am as a trial attorney.
I see.
Yeah. I've had that precise instance where somebody had a prior that was for burglary of a coin-operated vending machine, and they were charged with
They
the
were
habitual.
charged with.
But not in the proportionality analysis, like subsequent, right?
Well, ordinarily, it ends up being burglary of a dwelling that's used. And so when we're talking about that, I mean, it's sort of back to what Chief Justice Coates was asking at the outset. Isn't that getting close to something that most of us would consider to be per se grave and serious because of the potential for violence to result or some harm to come to the occupants of the dwelling?
Yes, and I do understand that analysis. I do understand some of these are difficult. I don't agree with the per se designation, but you can certainly entrust the courts can determine whether a crime is per se, or not, not per se grave and serious, but grave and serious in a particular instance. I think that that's where you look at, in this particular case, this was a crime of opportunity, and these were the facts that could be presented in an abbreviated proportionality review, which is that this is a second-degree burglary. It's necessarily less serious than a first-degree burglary, for example. You would also look at the fact that this was a situation in which this was a fire and these houses were due to be burned down, so they were vacant, and the motive of the defendant, it was to go into a home and take items that were potentially going to be destroyed or engulfed in flames anyway. Those are factors that could be argued to a court in an appropriate abbreviated proportionality analysis. And that's why the per se designation is so problematic, because we're supposed to be weighing the relative seriousness of the offense. But again, you go back to the fact that this was a 48-year sentence. It should have been between 4 and 12 years, but for the fact that she has 3 prior drug offenses. And I will say that one of those prior drug offenses would no longer qualify. And I just want to point out that in the 1990s, we used to have the statute 1818-405, and it included everything: possession with intent, distribution, manufacturing. Subsequent to that, we started moving out simple possession cases to 1818-403.5. That's what, in 2011, the habitual statute started excluding as being the basis or being a conviction that can be used for purposes of the habitual statute. Unfortunately for Ms. Wells, she was convicted in the 1990s, and so that was no longer an F6, which would have been an F6 in 2010, but yet it still would be not an offense that could be the basis of a habitual charge. So I just want to point that out, because I do think that those are circumstances that courts can consider when considering whether the 72-year sentence in this case was appropriate. I would like to reserve the rest of my time for rebuttal, if I may.
May I just ask you, if we were to agree with you, is the remedy here remand?
I think that, well, first of all, the abbreviated proportionality review is certainly a de novo review. So this court can consider the issue and can declare that it raises the inference of gross disproportionality, or it can declare that it does violate even the Eighth Amendment and just remand it for resentencing. All of those are possibilities. I do note that other cases by this court have indicated in the absence of a need for refined analysis, this court can make that determination. If you don't feel like you can, or that there's further factual development that does need to be considered, then a remand would be appropriate as well.
Thank you.
Other questions? You may.
Mr. Chief Justice, and may it please the court, on behalf of the state of Colorado, Assistant Solicitor General Michael McMaster. The defendant in this case seeks to fundamentally alter the Eighth Amendment and its proportionality principle.
Mr. McMaster, can I ask a favor? Can you pull that up just a little bit? Yeah, I want to make sure
Sorry,
I
I'm
can
a
hear
bit of
you.
a quiet talker. Is that better?
Yeah, thank you.
All right. The defendant also seeks to pick and choose what legislative enactments benefit her and then to constitutionally enshrine those changes. And finally, she invites this court to reverse itself less than 4 years after issuing its decision. All the while, she hopes that this court will ignore the stunning and egregious nature of her crimes, her escalating criminal behavior, and her lengthy criminal history. This court should decline the defendant's invitation. Instead, this court should affirm the Court of Appeals. I hope to build on the discussion that we've already been having this morning. I think I would like to be guided by 4 ideas. The first is I'd like to address the limited nature of an abbreviated proportionality review and the irrelevance of legislative changes to that framework. Second, drug crimes have been and continue to be a grave and serious crime. Third, this court's opinion in Rudder was correct then and it remains correct now. And finally, I think I'd like to apply these legal principles to the defendant's individual sentences. So with respect to this first point, courts should not consider subsequent legislative changes when conducting an abbreviated proportionality review. The scope that's been established for this framework is that during an abbreviated proportionality review, a sentencing court looks at the gravity or seriousness of an offense and the severity of the punishment. Contrast that with the extended proportionality review. During the extended proportionality review, the sentencing court conducts an intra-jurisdictional comparison and an inter-jurisdictional comparison. And by necessity, those comparisons are going to be across time. And what the defendant is asking this court to do is essentially collapse that distinction. When we start comparing a sentence that the defendant received previously with a sentence that the defendant could have received either now or at some other time based on legislative changes, that is functionally the same as an intra-jurisdictional comparison.
But why doesn't this go to gravity? And I'm picking up on Justice Hart's question from the last argument. I mean, it arguably goes to a culpability. If you're just an addict and we want to get treatment, that would suggest there's less culpability. And my concern is, as I expressed to Mr. Kozlowski, on your argument, basically we're never going to consider the legislative changes because we basically never get to the extended review, or almost never. I'm troubled by that. So could you address that?
Yes. So both in response to your question and the earlier question about culpability, the 2 parts of an abbreviated proportionality review are the gravity or seriousness of the crime and the culpability. And we have guidance from the U.S. Supreme Court in Solem as to the factors that we consider when making that judgment. And the 2 main factors that kind of have been distilled over time from Solem are the harm caused or threatened to the victim or society, and then and again the culpability of the offender. So, and all the other factors listed in Solem, they do not include legislative changes.
Sure, but why doesn't a legislative change go to culpability? The legislature said, we're putting too many people in jail who really need treatment. Why is that not appropriate to consider as part of the gravity of the offense?
So I think this leads us really to another point why legislative changes are inappropriate and abbreviated
But I
proportionally.
really would like an answer to my question first, if you would.
No, I want to answer your question. And the
All right,
reason why
thank you.
is that those legislative changes, we could infer they go to the culpability, but those legislative changes are the result of a political process that takes into account a great deal more than a judgment as to either the culpability of the offender or the gravity or seriousness of the offense. And I think, if we look at Ewing, the court discussed that these 3 strike type laws were relatively new at the time. They represented a shift in the way legislatures across the state were, it was a shift in penological judgment or an adoption of a different penological theory, and it was an emphasis on incapacitation and deterrence. Likewise, a legislature could shift towards rehabilitation. That may be what we have here, but there are other considerations that the legislature takes into account that are independent of the nature of the offense, and that really goes to the harm to the victim or society and the culpability of the offender.
So I get that, so let me flip it around with you. Your whole argument presumes that when the legislature passed these drug sentencing laws 20 years ago, 30 years ago, they were saying grave or serious. Why doesn't the same argument apply to back then? So we can't assume that the court or the legislature was saying it was a serious offense 20 years ago either. It was the product of all kinds of factors. So we don't have grave or serious then or now. We have to decide based on the facts.
Respectfully, Your Honor, I disagree with the premise of the question. I am not arguing that it was grave and serious because 20 years ago the legislature said so. In fact, quite the opposite. The basis for determining that these drug crimes were grave and serious was independent of the sentence that was prescribed by legislatures 20, 30 years ago, just as is independent of the sentence prescribed by the legislature
All right,
today.
so help me understand the factors that decide that. So 20, 30 years ago, we had the war on drugs, and that was societal's mores. This is really a problem. Today, we have a different view. Why don't we get to consider the view today?
Justice Kennedy's opinion in Harmland, I think, is the best explanation of this, where he talks about the harm that drug crimes pose to the victims themselves, but primarily to society as a whole. And these drug crimes have a compounding effect, is what he talks about, this pernicious, I'm trying to remember the exact words, but the pernicious nature of the drug crimes is that they lead to not only more crimes, but greater and more serious crimes. And that was the nature of drug crimes then.
But was that
hasn't
not a
changed.
product of the time? And I'm really just trying to understand. I promise I'm just pushing it a little bit. But wasn't that Justice Kennedy's view a product of the time in which he uttered it? Perhaps if we asked Justice Kennedy today, maybe he'd have a different view. I don't know. But why is Justice Kennedy's view in 1980 or whatever your Harmland was locked in time?
I read nothing in that opinion that is temporally limited. The nature of drugs hasn't changed. The nature of this effect hasn't changed. Perhaps the best example of this pernicious evil of drug crimes is this case. Yes, Ms. Wells-Yates was convicted of prior drug crimes, but what did they ultimately lead to? They led to the triggering offense in this case. And I absolutely disagree with the characterization that the triggering crimes here were not grave or serious. They were outrageously grave and serious. And I think that that's clearly reflected in the record. I encourage this court to read the sentencing transcript and to read the pre-sentence report, pre-sentence investigation. And it reflects this escalating nature of the escalating criminal behavior and the lengthy criminal history of Ms. Wells-Yates, and that is evidence of the nature of these drug crimes, and that's precisely what Justice Kennedy predicted. Nothing about that has changed.
Let me ask you one more question. I promise you I'll leave you alone. So you could, let's not, I don't know the facts of this case. Let's take a hypothetical where, yeah, it's escalating drug crimes leads to burglary because the defendant is just trying to feed his or her habit, is a total addict and starts robbing, banks or whatever else to feed the habit. Isn't that something we would consider in a grave or serious analysis and goes to culpability? This is just an addict who went down a bad rabbit hole because of the addiction.
Your Honor, I think The answer to your question is you could consider the addiction with respect to their culpability. Where I think there is tension is that I don't think the legislative changes are evidence of that. If you want to look at the individual facts, and again, this case is a great example, the PSI makes it clear that all of Ms. Wells-Yates' crimes were at least some way related to her drug addiction. And that could be a factor considered in the culpability. But I disagree that the legislative changes could do that. And again, that's in large part because there are a variety of reasons why those legislative changes could happen. Another example is the legislature can move away from incapacitation for funding reasons. Prison overcrowding is without a doubt a real issue. And in fact, the 2013 changes at issue in this case reflect that. Specifically, in 18.1.3, 104.5, sentencing judges are required to consider the cost of imprisonment before sentencing a level 4 drug offender to prison. That has absolutely nothing to do with the seriousness or gravity of a particular crime. And frankly, it may not have anything to do with the appropriateness of a prison sentence and everything to do with the state's scarce resources. Those factors are why we can't read too much into these legislative changes, in addition to the fact that these legislative changes are outside of the framework of an abbreviated proportionality review.
Can I come at this from the other side of the abbreviated proportionality equation? There, you're comparing, obviously, the gravity and seriousness of the offense, but you're also comparing it against the harshness of the penalty. And why can't we take into account, or why can't sentencing courts take into account legislative changes when examining the harshness of the penalty that's being imposed?
Well, first, let me echo what was said earlier, that second step is oftentimes skipped, so I'm glad we're not skipping it. But the answer to your question, I think, is that the Eighth Amendment doesn't demand or prefer any given penological theory. It allows for states to fine-tune or experiment with different theories, and so
Fair enough, and I totally agree with that, right? So let's say the legislature, as a policy matter, has said the alternative to incarceration is rehabilitation. We're going to divert these folks into treatment because of the nature of their addiction. But still in that abbreviated proportionality review, we're examining the gravity of the offense, even if we think it remains a serious offense. We're comparing it to the harshness of the sentence being imposed. And I struggle to understand why the fact that, on April 1st, this person gets, July 1st, the person gets 2 years, but if they had committed that same crime on June 30th, it's 24 years.
Respectfully, Your Honor, I'm not sure why that would draw an inference. So let me answer it this way. When comparing to the severity of the offense, you're not comparing the offense to different possible sentences. And I think this goes back to what I was saying earlier about collapsing abbreviated and extended proportionality review. And this perhaps is a good reason because there's an analytical distinction between comparing the severity of an offense and the sentence given for that offense with comparing a sentence given with other possible sentences. So I think it's just outside of what that analysis allows for, and it's outside the framework that was first set forth by the United States Supreme Court.
And I understood your response to be that the extended review, it takes into account intra-jurisdictional and even inter-jurisdictional, and those could be across time, but even the I guess I still struggle to understand why, just because it's appropriate in the extended review, it's therefore inappropriate in the abbreviated review.
I think the primary basis, if we backtrack and we look at where that framework was established, again, we're talking about Justice Kennedy's decision in Harmelin. And the way I read that, the reason for drawing these lines and creating these steps was animated primarily out of deference to the legislature. And that he lays out, I believe, 5 principles at the beginning of his opinion that guide that analysis, and one of them is deference to the legislature. Another one of them is an acknowledgement that when it comes to a proportionality challenge, a successful one is exceedingly rare. So I think we've all been struggling this morning with the fact that it seems unlikely we'll find an example of a grossly disproportionate sentence, and that's exactly the boundaries that the U.S. Supreme Court has established. It is going to be exceedingly rare that that's going to happen. But I think, but to return to your question, why we do it that way is out of respect for the legislature, and it's out of respect for the sentences that they have prescribed for a given crime at that time. So if the legislature wanted to apply the new sentence, the new lenient sentence to crimes that occurred before July 2nd or before July 1 in your example, it could have done that. And as this court recently told us in Stellabot, when they set a date, the legislature means it, and we must understand that to be a conscious choice. Now, I understand the response that was made earlier that that particular date is more of a clerical one, but the decision of prospective or retroactive application is absolutely a choice that the legislature is making. So I think in ultimate response to your question, there's going to be that difference because any change has to have a date certain by which that change occurs.
Thank you.
So let me follow up on your comment about respect for the legislature. So I think in general, we can agree that the punishment that the legislature sanctions for different crimes is based at least in part on what the legislature thinks is grave or serious, right? First-degree murder, harsher penalties than for theft, right?
I agree with that.
And so why can't we consider, or why shouldn't we consider changes by the legislature in punishment when we're trying to figure out whether a particular offense is per se grave or serious?
So is your question cabined to when this court decides if a particular crime is grave or serious or not, is per se grave or serious or not whether it's grave or serious?
Right.
I think the answer really is because the factors given to us in Solem don't account for that. And
But those factors go to whether the offense is grave or serious. I'm not talking about those. I'm talking about per se grave or serious, what courts deem to be per se grave or serious. I mean, if the legislature has a change of mind in terms of the gravity or seriousness of an offense and consequently the punishment that's appropriate for that offense, and if that's some evidence of the evolving standards of decency that mark the progress of maturing society, should we take those changes into account in deciding whether an offense is per se grave or serious?
I don't believe so, and the reason is that what makes a crime grave or serious is not what the legislature decided to punish it as. And to echo what was said earlier, the reasons why a legislature may choose to change are entirely possible to be independent from the view of whether it's grave or serious. Earlier, my colleague offered an example of sex offenses, and currently most sex offenders are required to go through treatment. And if in the future we become really good at that treatment, the legislature may decide to change the sentence for sex offenses based on that available treatment. But that says nothing about the gravity or the seriousness of the particular crime, because...
Are you saying that if the legislature today said, from now on, in terms of 10 years to life in prison, we're going to say that certain sex offenses are going to be subject to probation, that in some way doesn't reflect the punishment that the legislature believes is appropriate for that crime and the type of gravity or seriousness of the crime?
There's two parts there. It absolutely reflects what the judgment of the legislature of what they think the appropriate punishment is. But when asking what is the harm to a victim or what is the harm to society, the prescribed sentence doesn't answer that question. It's a separate question. And I'll offer
I
a counter.
agree it's a separate sentence, but your position seems to be it's irrelevant. Why is it irrelevant? I mean, I totally agree. It's not necessarily dispositive on whether the legislature viewed it as less grave or serious now, but why is it complete? Your position, and again, I don't mean to put words in your mouth, but it seems to be that it's completely irrelevant, and I don't understand why it would be.
To be clear, it would be relevant in an extended proportionality review question. It's not completely irrelevant. I'm not drawing that hard of a line.
All right, I apologize.
No, that's all right. I think I'll offer a counterexample.
No, go ahead. No, you're still.
And this was the best example I could think of what it would be for a crime to cease to be grave and serious. And that is the crime of horse theft. In Western states like ours, 100, 120 years ago, if you stole someone's horse, that was a pretty serious crime because you might have left them in the desert. I was unable to find in Colorado, but certainly in other states a while back, they'd hang you for that. The nature of our society has changed such that stealing someone's horse no longer has that same gravity or seriousness. The reason for that has nothing to do with the sentence imposed by the legislature, and it has everything to do with the harm threatened to the victim or the harm threatened to society. So I think that would be the counterexample I would offer.
Right, but to follow up on that hypothetical, if we had decided 100 years ago that that was a per se grave or serious offense, today we would not look at the harm to society. We would just say, it doesn't matter that the legislature has changed. It's a per se grave or serious crime. And that's what my question goes to. Should we consider legislative changes, not in determining whether a crime is grave or serious under Sullivan versus Helm, but in determining whether it's a per se grave or serious crime? Does that make sense?
I think so. And my first response is, unfortunately, we don't have a lot of guidance as to what makes something per se. And that's, I think, just a function on the limited number of cases that this court has decided, which, as an aside, is again evidence of how exceedingly rare proportionality challenges are. But to continue with the example, if it had been 100 years ago determined to be a per se grave and serious crime, and this court were to revisit it, I think that analysis should be based on the harm threatened by that particular crime that's inherent to the crime, not what the sentence is or could be or used to be. That's why I think it's not particularly relevant. That's why these legislative changes are not relevant within the context of an abbreviated proportionality review.
Can I just for clarification with regard to this entire exchange, so do I understand you then, with regard to your earlier statement about the choice with regard to retroactivity, to be saying whether or not the legislature chose to retroactively apply a reduction in sentence would have nothing to do with the determination whether a prior crime was grave or serious?
I think if it were to make it retroactive, that would be relevant because it would then be applying.
Sort of a ratchet effect that only has an effect if they make it retroactive, but not if they don't make it retroactive?
Well, if they make it retroactive, the court has to defer to that.
And so that would indicate that committing that crime even back then, were it to be tried now, would have this reduced sentence. But should that, in your analysis, have any effect on whether it's grave or serious for purposes of an abbreviated proportionality review?
I don't think I followed that question. I'm sorry, Your Honor. Can you repeat that?
I guess I'm simply asking, in line with your argument, both earlier with regard to retroactivity and now with regard to the lack of effect in a
for purposes of an abbreviated proportionality review, the determination whether a crime is grave or serious. I take it you're saying now the legislature's determination of the penalty does not have anything to do with whether we would find that to be grave or serious. And therefore, I was saying, would that extend even to if they apply to reduce sentence retroactively? Would that have any effect on whether the prior crime should be treated as grave or serious?
I understand now. No, I don't think it does for all of the same reasons. Certainly, if it was retroactive, it would apply retroactively. And there might be reasons that the legislature made that particular judgment. But when they don't make that judgment, that's still a choice entitled to deference, just like their decision to adopt a penological theory of incapacitation is entitled to deference. And the Eighth Amendment does not require a legislature or a court to choose one or the other. It's entirely permissive under the Eighth Amendment.
I'm not sure, Mr. McMaster, if I understood, but I want to make sure. Your position is when the legislature's decision to make it retroactive or not is not relevant to whether they viewed the crime as grave or serious. Separate from that, though, you're saying the court should defer to the legislative judgment in that regard. Is that your point?
Yes, Your Honor. The sentencing choices made by the legislature are what Justice Kennedy talked about were entitled to deference at that time.
But that's separate from the question of whether it is grave or serious.
That's right.
Okay.
The question of gravity or seriousness is done independent of what the legislature sets a particular sentence at. And that's just because the nature of a crime is independent of how we choose to punish it. With these remaining moments, I want to briefly address this court's prior decision in Rudder. And I think as a threshold point, I want to note that even if this court does want to reconsider that decision, this simply isn't the case to do that. Regardless as if we consider Mrs. Wells-Yates' crimes in combination or individually, the outcome is the same. So this case really is not that vehicle. Nevertheless, the decision in Rudder was correct. And I think when we talk about prior cases that say we look at crimes in combination, we're leaving out some important words. And what's important here is that on a proportionality challenge, it is the defendant's burden to show that all of the crimes are lacking in gravity or seriousness. That means to rebut that claim or to dispel the inference of gross disproportionality. It's not that all of them must do that. It's just that there must be a sufficient amount of gravity or seriousness to dispel that inference. So it's really a confusion between necessary or sufficient conditions. The defendant's argument really attempts to flip this burden and to require that the state show all of the crimes in combination are sufficiently grave and serious. That is not the standard. It is the defendant's burden to show that all of the crimes are lacking in seriousness. So in Rudder, it was sufficient that the triggering offense, which was the manufacturer of methamphetamine, that alone was sufficient to dispel an inference of gross disproportionality for a 96-year sentence. At that point, it was simply unnecessary to go any further with the analysis. That is still consistent with prior case law, and it's consistent, prior case law from this court, and it's consistent with case law from the United States Supreme Court. Now, in Rudder, a 96-year sentence was appropriate for the manufacturer of methamphetamine. In this case, one of the triggering offenses is the distribution of that very same drug. And if 96 years was appropriate there, 64 years is appropriate here. And when we're talking about that particular sentence of the 64 years, what should be 64 years for the possession with intent to distribute, I also want to briefly note that even if this court does consider subsequent legislative changes, even today, the distribution or possession with intent to distribute, our legislature has designated as an extraordinary risk crime. And what that statute says is that it is an extraordinary risk of harm to society. So I would suggest that it would be remarkably inconsistent for this court to determine that these crimes are not grave and serious based on legislative changes, while at the same time, our legislature has designated an extraordinary risk of harm to society. So with my final moments, I do want to conclude by once again calling upon Justice Kennedy's concurrence. While I freely admit that he's far more eloquent than I, the one thing that his opinion is missing is a demonstration or an example of what he calls the pernicious effects of drugs. And as I mentioned before, this is that case. This case provides a clear example of the dangers that drug crimes pose to our society. The defendant's sentences are proportional to her crimes, and I urge this court to affirm the Court of Appeals. Thank you.
Thank you.
So a couple of things that I wanted to touch on is there's been a lot of talk about the Harmlin opinion. And I just wanted to note that in Harmlin, that was not only a product of the time, which was, as Justice Gabriel pointed out, was part of the war on drugs, but it was also in deference to the legislative determination in that case and at that time below to treat transporting 650 grams of drugs, which is essentially a large-scale kind of distribution scenario, to treat it as the legislature did in that case. Here we have a massive change to our entire drug laws and our entire criminal code to treat drug offenses in a rehabilitative rather than a punitive manner. And this information alone presents an additional factor, an additional consideration that must be taken into account in a proportionality review. The same thing in Ewing. It was in deference to a very clearly proscribed legislative scheme that the court was called upon to affirm and to uphold and give deference to, with no additional information calling into question whether the legislature would still want to pursue that course of action. That's why we're postured differently here today, that and coupled with the per se practice that we have here. And so right now, the courts should be deferring to this broad-scale legislative change in assessing that proportionality at the abbreviated stage. I see that I only have 3 minutes left, and I just want to open it up for any questions at this point to see if anybody has anything that they would like me to respond to.
I have one quick question that has to do with the 64-year sentence. Correct me if I'm wrong, because there are 3 cases here, and I might be conflating a couple of things, but I thought I understood the AG to be suggesting that we would just return this for correction of the minimus to change that to a 64-year sentence. Do you have thoughts on that?
My only request would be that this was a 48-year sentence plus the 24-year sentence consecutive for identity theft. Everything else was run concurrent to the burglary charge, which the court considered kind of the main charge here. If it does go back and you don't grant relief on the proportionality question, my only request would be that it goes back to subsume that 64-year sentence within the already existing 72. That means that it would be congruent, but not necessarily concurrent. Does that?
Understood.
Yes, okay. And that's just to uphold the original sentence that was imposed, if that's what this court decides to do. I would like to talk about, again, the Rudder question was discussed. And in that case, I do think that it failed, or the court failed to consider the change to the drug felony involved in that case. Rudder received 96 years, when a few months later, he would have received a maximum of 4. I don't think that the court adequately took that into consideration. The same is true here. 64 years, a few months later, she would have received 4, and if it was under the habitual, then it would be 4 times 4, 16. That would be the max under the habitual if it was just a few months later. So I wanted to hit on that and make sure that that was very clear. I don't think that the court here or below did take into consideration the fact that that was applicable to Rudder's case, and it is applicable here as well. With that, then, I would just ask the court to either declare Ms. Wells' sentence violates the 8th Amendment and remand for resentencing, given our changed drug laws, or find that it raises the inference of gross disproportionality and remand for an extended review. I'd ask the court to clarify that courts are to look at both the triggering offense as well as prior offenses in combination when conducting a proportionality review. And we've asked that the court conclude and direct that courts should and can, at a very minimum, consider legislative changes when conducting a proportionality review. And we'd ask the court to declare that narcotics-related offenses are not to be considered grave and serious, certainly not per se. Thank you.
Thank you. I'd like to thank both counsel for their arguments. Case will stand submitted, and we'll move on to our last argument for the morning, People v. McRae. Give counsel a minute to get situated. Like you're both ready to go? Counsel for petitioner, why don't you go ahead and start your argument? We've set this one, by the way, only for 30 minutes. You all both know that. Okay.
Good, thank you. May it please the court, good morning. I'm Mike Whitney. I represent the people of Colorado in this case. We appealed because the trial court in Adams County imposed an illegal sentence. In the guise or in the terminology of a proportionality review, the court retroactively applied new drug law sentencing rules that had come into place after the offense in this case. There are really 2 points of controversy, 2 main points of controversy between the parties. Both parties agree that the new drug laws hadn't taken effect yet, that they didn't apply to Mr. McRae's case. The controversies are whether the court applied those new drug laws retroactively and whether the court was entitled, essentially, to apply those new drug laws retroactively, whether the court was entitled to consider those drug laws and essentially to take sentences from those laws and place them in this case. In terms of the record, what I would point to is that there are several places where the district court makes findings that the new drug laws apply. The district court at one point says it finds that the difference between 16 and 64 years is grossly disproportionate. And what the district court is doing there is comparing the drug law sentence that would apply under the new law to the sentence that would apply under the applicable law. The court says that it finds that the offense, the triggering offense in the case, is a level 3 drug felony. The Court of Appeals and Mr. McRae point to another portion of the transcript where the court goes through 3 factors that it considered After acknowledging that drug offenses are grave and serious per precedent from this court, precedent from the Court of Appeals, precedent from the Supreme Court, the court then examines factors. It labels them parts A, B, and C. In Part A, the court considers that there were no weapons and no violence in this particular offense. That is a consideration of the specific facts of this offense, not the general conduct of a drug offense. It's also essentially a consideration that this is not another type of offense. This is not a second-degree assault. This isn't something where weapons or violence are involved as part of the elements. It's essentially a drug offense. So the court is saying there, this is not another type of offense. Part B, the court says these crimes were drug-related, which, if you follow the court's logic, is it would go like this. Drug crimes, the court recognizes, are considered grave and serious, but these particular drug offenses were not grave and serious because they were drug-related. It essentially nullifies the first part of the analysis. In Part C, the court considered that they were not substantial distribution cases for monetary gain, but essentially for personal use. In the triggering offense, Mr. McRae sold methamphetamine. He sold 6 grams of methamphetamine. He did that for monetary gain. According to the representation of his counsel, one of his prior offenses involved 45 grams of mixed drugs, methamphetamine, cocaine, other drugs. In another case, according to the representation of his counsel, he was in possession of 28 grams of methamphetamine. Those are distribution amounts. Those are not personal use amounts. He was convicted twice. Out of 5 prior felonies, he was convicted twice of possession with intent to distribute. In the 2 other cases, he was charged with possession with intent to distribute and pled guilty to simple possession. So the only evidence considered by the court in looking at proportionality in this case was the legislative change and the representations of counsel, those factors that the court went through. And those factors amounted to essentially, these are drug offenses. Part A, these are drug offenses. Part B, these are drug offenses. Part C, these are not what the elements say they are. These are not intent to distribute. This is personal use.
Weren't those factual questions for the court to decide in its discretion? I mean, the gist of your argument seems to be the court applied it retroactively. That was wrong. Excuse me, but it seems to me the court said, well, I can consider legislative changes, which is an issue that's before us in these 3 cases. I can consider there was no violence here. I consider this guy appears to have a drug addict problem. And I can consider, I look at the priors. It was all of those things, and said, putting all those things together, I find an inference of gross disproportionality. Why isn't that something entitled to deference here? And maybe my question is, what factors do you think the court is allowed to consider? Because you basically have eliminated all of them. And I'm being a little facetious with you, but it's not clear to me what's left for the court to consider in an abbreviated review. If the court can't consider the facts of the case, can't consider the legislative changes, what was the court supposed to consider?
Well, my issue here is that the court considered only legislative changes and considered them in the context of, and that really goes to my second point, but considered them in the context of what was a typical drug offense, really, in all the particulars. And my point about the court's holding is that the first one is just the nature of a drug offense, that it typically is not violent or using a weapon, because it would be charged otherwise if it were. The second one, the court literally just refers back to the fact that it's a drug offense. And for the third one, it's contradicted somewhat by the nature of the offenses that were offenses of conviction, both in this case and in the predicate cases. So that my point there is that while that's offered by the Court of Appeals and by opposing counsel as a justification for the court's departure here, it actually doesn't justify the court's departure. The only justification, if there is one for the court's departure, is the legislative change. And that is what the trial court did here. It applied the legislative change retroactively and did so very much expressly, very much in terms of, I'm finding this is a level 3 drug felony and I'm imposing 16 years versus 64 here. And the second point that I know the court has heard a lot of discussion about this morning, the second part of my argument, is why that doesn't work, why that is a poor policy. And I think the court's heard this many times already this morning, but the legislature makes decisions about penological approaches to crime. And here, record is very clear that the legislature made a decision to address drug crimes with rehabilitative measures. And the previous philosophy was incapacitation. What I'd like to point out is that in my reading of the case law, whether a crime is grave or serious has to do with conduct. It has to do with elements. The court talked about in Solem the harm to the community, the harm to the individual, and the culpability of the offender. When they talked about culpability of the offender, they talked about whether it's intentional or negligent. I think today the court has pointed out, and I think the consideration of the gravity or seriousness of the offense and the punishment are somewhat interrelated, right? We would want our legislature to impose a serious penalty for a grave offense. But when we're looking at whether the offense is grave or serious, the case law hasn't previously considered what the sentence typically is. And what I would posit as a hypothetical would be if we get a new legislature next year and they decide that aggravated motor vehicle theft is a big problem in Colorado, and they pass a bill that says for a first offense for motor vehicle theft, we are imposing a mandatory 30-year sentence. That bill passes, becomes law. Does that then mean that motor vehicle theft in its essentials has changed? Has the conduct changed? Has the culpability of the offender changed? Is the person who commits motor vehicle theft then acting intentionally? Are they acting with greater malice than they were the year before? Or is it a case where the court would look at the conduct and conduct a proportionality review and say, this conduct doesn't fit the harshness of this penalty? That's the problem with relying entirely on legislative enactments to decide whether something is grave or serious. It should be about, was the conduct itself grave or serious?
Mr. Whitney, but it doesn't change any of the conduct or the culpability, but isn't the reality is it changes or reflects the change in perception? I mean, as Justice Gabriel's been talking about in the 80s, I think the perception was people who use drugs are bad. Today, the perception is people who use drugs are sick.
And I think that's the way that we're addressing the problem. I guess what we're looking at is the harm to society. And the perception is that there's a harm to society either way. The perception is this is harmful behavior. We're going to address it through rehabilitative efforts rather than incapacitation. And that's a policy decision.
I'm sorry, I guess I struggle with that though, because in light of that, you're still saying, and yet the court will address it by incapacitation.
Well, I think the court will apply the tools that the legislature has given it. And in this case, the legislature mandated a 64-year sentence for the conduct that Mr. McRae committed at the time he committed it. And the tool that the legislature at that time mandated was incapacitation for 64 years.
I'm going to ping pong you here. So, but we've said we determine what's grave and serious, not the legislature.
Correct.
Well, but shouldn't we, when we make that determination, look at perceptions of what is wrong? I mean, Mr. McMaster before talked about the the horse thief thing, which I think really is a practical consideration, not a perception one. Here, we're talking about the perception of the criminal.
And I guess the issue I have is with perception. I think the harm to society from drug crimes is very real. It's not just perceived. And I think as someone with experience in the courts, we're all aware of that drug crimes drive other crimes, that they are the motive and the impetus for other crimes.
That's why they're a felony. I mean, I guess some aren't anymore, but I guess I'm asking, how does the change in perception impact us? 0?
Well, it doesn't affect the conduct.
Right, I agree with you.
I guess 0 is my answer. I mean, I think I'm fairly locked into that answer because it doesn't affect the essential nature of the harm. It would be, let's use another example. I've talked in my brief about DUI, so I'm not going to talk about that now. But let's talk about second-degree assault. Just a few years ago, second-degree assault was a mandatory 5-year sentence. First offense, second offense, mandatory 5-year sentence. Recently, the legislature removed the mandatory 5 years. Now, is that a statement that there's a perception that we're no longer concerned about using a weapon to cause bodily injury? That's a policy change that's designed to give judges more sentencing discretion. It's not a comment on, is this a grave or serious offense?
But some are reflective. I agree with you on the assault. But would you agree with me that there's a change in perception about drug users?
I agree that there's a change in the perception of how we should deal with the problem. Yes.
Well, do you disagree with the concept that we used to view people who did drugs as being bad to now we perceive them as being sick?
I would say yeah.
You agree with that?
I do.
Okay.
I'd like to reserve my remaining time for rebuttal if I could. I think I have about a minute.
Please.
Thank you.
May it please the court. My name is April Elliott, registration 37856, and I'm here this morning on behalf of defendant appellee Clifton McRae. I am asking this court first to affirm the trial court sentence of 16 years, or in the alternative, to affirm the lower court's finding of gross disproportionality and remand this case for an extended proportionality review. The issues before the court this morning for this case are a bit more limited than the prior 2 cases. Specifically, this court granted certiorari with respect to 2 issues. First, simply stated, we are here to determine whether a sentencing court can consider subsequent legislative changes during an abbreviated proportionality review. And Your Honors, I think controlling case law makes that answer abundantly clear. Yes. In 1994, this very court held in Mershon, while legislative decisions as to the seriousness of applicable punishment is not determinative, that evaluation is entitled to substantial deference. That notion was adopted twice more that year by the Court of Appeals in Penrod and Anaya, stating we necessarily conclude that given the General Assembly's current evaluation of the seriousness of the offense at issue, this factor should be considered in determining whether a defendant's sentence is grossly disproportionate. This was reflected again and again and again, all the way through as current as last year. Earlier this morning, one of the Attorney Generals, Mr. Kozlowski, stated to this court that this court doesn't need to go looking for an Eighth Amendment violation. To the contrary, every court has to go looking to avoid an Eighth Amendment violation. And that is the very purpose of a proportionality review. And it is what the trial court in this case aimed to do and did do. I will concede that case law is clear that finding gross disproportionality is exceedingly rare. But as I argued to the Court of Appeals, this is that rare case. Mr. McRae's offense was committed 1 month after Senate Bill 13250 was signed into law. That was signed in on May 28th of 2013. His date of offense for selling 6 grams of methamphetamine to his live-in girlfriend, who was a paid confidential informant, was committed on July 2nd of that same year, 3 months prior to these laws going into effect. So that is the setting, the scene in which this case was being litigated. That is what was going on at the time of Mr. McRae's sentencing and when I first raised these arguments. So the court was well within its right to consider what the sentence would have been under the old law versus the new law. That said, he went to great lengths to state at that sentencing hearing that he was not applying this retroactively. Instead, he was comparing these sentences as part of its abbreviated proportionality review, which he is required to do under the law. And legally, he is entitled, as I just argued, to consider subsequent legislative changes.
But I think the challenge here is it smacks of an end run.
And
So help me be comfortable with that.
And I understand that. And I think the first part of his analysis was absolutely correct. I think he was correct in considering the facts and circumstances of the predicate offenses and of the triggering offense. In doing so, he considered the facts surrounding those, noting that they were not for monetary gain. I've obviously represented Mr. McRae since 2013. He lived in a trailer with his mother and his living girlfriend. It was not the home of a drug dealer. But in making his findings, he did properly arrive at a finding of gross disproportionality. The problem was, rather than proceeding to the extended proportionality review, he looked to the general legislature for its determination of what the proper sentence should be. And I think it's difficult not to concede that he skipped the second part of the proportionality review. But to be clear, the imposition of a 16-year sentence was not ever what I requested. It obviously was not what the district attorneys ever requested. That was a sentence that was imposed at the conclusion of the hearing by Judge Popovich. But I do think his finding of gross disproportionality was absolutely right in light of the subsequent legislative changes as well as the facts of his underlying offenses.
Had you actually just requested extended proportionality review, or how did that unfold?
Pardon me?
Did you request extended proportionality review, or how did that, what was the request below?
So the request below, I filed a motion for extended proportionality review of the habitual sentence. That is contained in the court record, and I apologize, I don't know the pages. But I filed that on December 22nd, shortly after Mr. McRae was convicted on December 5th of 2014. Obviously, it's titled Motion for Extended Proportionality Review. So we went in early January and conducted the extended proportionality review. And each side had its opportunity to argue, as is required under the law. As was stated earlier, it is our burden to prove gross disproportionality. And I argued the facts and circumstances of his underlying case. Judge Popovich was intimately familiar with the facts of this case because he had presided over the trial. And the prosecution had its opportunity to rebut that evidence. And we came back for a subsequent hearing for sentencing. And it was at that time that Judge Popovich made his detailed findings of facts, finding disproportionality, and then simply imposing a 16-year sentence.
The court didn't have to impose that 16-year sentence, is that right?
Correct.
I mean, the court could have done anywhere, if it found gross disproportionality, anything under the 64 years.
Correct.
And that, I mean, I'm just thinking out loud here, that would be a response to why this was not a retroactive. It turns out the court looks like it applied, the old statute, but didn't have to. And what your request to us, I think, is just that the court gets to consider the legislative change, but is not bound by it.
Absolutely.
All right.
Absolutely.
Could I take you back to that first step then? Assuming we agree with you and the court could consider the legislative change, would you run through the analysis why, even considering that, this crime shouldn't have been treated as grave or serious?
Why this particular offense, the triggering offense?
Right, because you want to get on to an extended proportionality review. But if this was a grave or serious crime, couldn't we still be then in an abbreviated review? So I'm asking you, using the legislative change as some evidence, as one factor we can consider, what's the rest of the analysis why this was not a grave or serious offense?
I think it goes to all of the other factors that are set out in Solemn versus Helm. So the motive of the defendant. Is this an attempt or a lesser included offense?
And so you'd be saying, for instance, I mean, how does the motive play here? That given the defendant's motive, that he wasn't trying to make money or whatever, but nevertheless was providing another person with a addictive drug, what's meth, a Schedule II prohibited drug. You're saying that wouldn't put it into the category of grave or serious?
I think, to go back to what's something Justice Gabriel said earlier, the drug addict who just ends up in a bad rabbit hole, and essentially every action that's taken is simply to feed a habit. None of Mr. McRae's offenses ever involved violence. One of his offenses was theft, which has since been reduced to a Class II misdemeanor, and that was for stealing tools out of
Let's stay with I didn't mean to cut you off, but your time is short. Let's stay with the distribution of a Schedule II substance. So are you saying then where we should go with this is, even though you provide a Schedule II substance to a known drug addict, if you're not doing it for profit, it's not great or serious? What's the rationale there?
I think that this is difficult for us to discuss because unfortunately we're working with a very limited record in this appeal. The transcripts from this trial were not made part of this appeal. That burden is incumbent upon the appellant. So we don't have the.
I'm not asking you what the defendant did, but what's the distinction you want us to make with regard to whether a crime is grave or serious or not?
Well, that goes to precisely what you just said. I think whether something is grave or serious is entirely dependent on what the defendant did. I think it's very dangerous to go into these per se categories because the facts that can lead burglary, going back to that example, it's a perfect example. The facts that can lead to a burglary arrest are tremendously vast. I do a significant amount of juvenile work. I represent juveniles who get kicked out of their home by their parents. They're 13, 14 years old. They get caught crawling through the doggy door after school to get food, and they get charged with burglary of a home. And that is not a grave or serious offense. That's a child trying to get food. So I think the per se needs to be done away with. And I know that's not one of the issues for this case today, but I think a grave and serious determination for any offense is incredibly fact-specific.
I find that very helpful because I think I understand your position better, but it seems to me you're not saying simply that a reduction of sentence by the legislature can be considered in deciding whether something's grave or serious, but rather there should never be a determination of grave or serious apart from the consideration of the circumstances of the individual case. Is that right?
No, I think that the court consider all of those things for grave or serious. I think the court should consider legislative changes because I think those are a direct reflection of our society's norms and values and mores. And that is at the heart of the Eighth Amendment. So I think the court absolutely should consider current legislative schemes.
I must have said that poorly. I didn't mean to suggest to that question whether the legislature could consider that. I was saying your argument now, as I understand it, and maybe I didn't fully before, is not just that the court can consider a legislative reduction in sentence, but rather it never can consider a crime in itself by its definition to be grave or serious. That legislative reduction should be considered along with all the circumstances according to which the defendant committed the crime. Seems to be
what I understand you to be saying.
I think that's right. I mean, I think, Solem is clear, this entire progeny of cases are clear that the courts consider the gravity and seriousness of the offense. That, to me, it may be incredibly nuanced, but is different than calling something grave or serious. Suddenly, it's gotten to be this really categorical definition that every court feels that it has to adhere to, as opposed to considering the gravity or the seriousness of someone's conduct.
Perhaps I can ask one follow-up as you're getting close. So even if the legislature reduced the sentence for first-degree murder from life without parole to life with parole, whatever, we could consider that, but you're still saying even a first-degree murder could not be considered grave or serious without entertaining the circumstances according to which it was convicted.
I don't want to get too far afield, but I think it's dangerous to go with this per se categorization of crimes. Obviously, first-degree murder is a very extreme instance. It's the most serious offense that we have. Obviously, I would like to see per se be removed from narcotics-related offenses, burglary too, for that matter, but just as a philosophical matter, I think trying to categorize something by its name and then punish somebody to decades in prison because of that without considering the facts and circumstances surrounding their conviction is dangerous. And I think it does threaten the Eighth Amendment. And I think that that's why this proportionality review is so vital to this stage of litigation. The second, I'm down to less than a minute, but the second issue before this court was whether the court erred in remanding the case, and I would simply say no. I think that is well within the Colorado Court of Appeals authority. That has been upheld by this court in Gaskin, where the Court of Appeals remanded, and that was upheld by this court. So I think the Court of Appeals did not run afoul of any jurisdictional authority in doing that. Given the case law suggesting that this court, well, all reviewing courts for that matter, are required to give substantial deference to trial courts' findings and sentencing, I do think that this court could simply affirm the trial court's sentence of 16 years, or in the alternative, I would ask this court to affirm the Court of Appeals finding and remand this case for an extended proportionality review based upon the trial court's finding of gross disproportionality. Thank you.
Brittany?
A moment ago, Chief Justice, you brought up murder. And there is some conduct that's inherent in the elements of a crime. As a prosecutor, I have to prove with sufficient evidence the elements of the crime. And when you look at whether a crime is grave or serious, I think you're looking at the conduct that gives rise to the crime, gives rise to the evidence that's brought against that person. And grave or seriousness is about, gravity or seriousness, pardon me, is about the weight of that conduct, the seriousness of that conduct. What's the harm from that conduct? What's the culpability of the person who commits that conduct? And murder is an extreme example, but it's obviously malum in se conduct that we would consider grave and serious. And the nature of the conduct here is essentially unchanged by the legislative means of addressing it, by a shift to rehabilitation. I'm out of time. I'm going to ask the court to impose a 64-year sentence here. Thank you.
Thank you very much. I'd like to thank both counsel for their arguments. The case will stand submitted, and the court will be in recess until 1:30.